Good day. My name is Mark Mellor. I'm an attorney with the Mellor Law Firm. Got a number of clients that are considering bankruptcy, have been calling from Lucerne Valley. So I thought it helpful to put together a video with some of the distinctions and differences between a Chapter 7 and Chapter 13 bankruptcy for those of you in Lucerne Valley that might be thinking about filing or might be thinking about bankruptcy. So what are some of the distinctions? One of the first distinctions is in terms of time frame. A Chapter 7 bankruptcy only takes about 90 to 120 days to finalize and receive a discharge from the court from all your debt. A Chapter 13, however, is relegated to a 3 or 5 year period. You might ask, well, what's the difference? Why the big time difference between them? And the difference is based on the amount of creditors you have, but it's also based on the amount of debt you carry, and also whether you pass something called a means test or not. What is a means test? Well, means test looks at your household size and the amount of annual income you bring in and the number of dependents you have and deductions from your income that you have. And based on that, if you fall below the statutory median income for California residents that's provided by statute, then you are eligible to file a Chapter 7 bankruptcy. If you fall above the California median statutory income that's provided for, then you're relegated to filing a Chapter 13. Now, why would you prefer a Chapter 7 over a Chapter 13? One, because of the time frame we talked about. You have a discharge of debt in 90 to 120 days. But a big reason people like Chapter 7 bankruptcy is because Chapter 7 discharges all of your debt, whereas a Chapter 13 is a repayment program to your creditors. So that 3 to 5 year period is a period of time where you're repaying your creditors back to the bankruptcy trustee or through the bankruptcy trustee who's making conduit payments to your various creditors and whatnot. Now, there may be a situation where you qualify for a Chapter 7 bankruptcy, but you don't want to file it. You want to file a Chapter 13 instead. You might ask, Mark, why would I want to do that? Well, one case is in the case of lien stripping. Although equity is coming back in residential real property right now, it's not back totally, and there's a number of consumers that are still underwater with their household mortgages and their houses. So when the first encumbering your home is greater than the value of your home, when you look on Zillow or you look to list your house, the value is less than the value of the first encumbering your home, and you have also a second deed of trust encumbering your home, then you can take part in what's called lien stripping, or remove the second from your property, which is immediate injection of income into the property on your behalf. But you have to fit within those narrow guidelines in order to make that happen. There's a special motion process that has to go down in order to effectuate that with a bankruptcy court. But you can't do that with a Chapter 7. It can only be done with a Chapter 13. I had a client come in here. They had a friend or a paralegal or some realtor or something file a bankruptcy for them, Chapter 7. They filed it. They got a discharge of the debt. Then they came in here and said, Mark, how do we lien strip the second from our home? And I said, well, it's too late now. You've filed a Chapter 7 and got a discharge, so there's no lien stripping available for you as part of that bankruptcy. But anyway, if you have certain circumstances that you're concerned about, or certain property you're thinking about keeping, do I get to keep the car, or do I get to keep the house, or whatnot, feel free to make an appointment. It's a free consultation with us here. Be happy to sit with you and talk about your particular circumstances.